to rise and kick off the debate around the title commencement and also the Principal Act amendments within this bill. I want to start with the title of the Act because I think that this actually comes to the core of the issue. The Act is titled the Children, Young Persons and Their Families, Youth Courts, Jurisdiction and Orders Amendment Act. Now, critically in there, we are cross-referencing the primary legislation which this bill amends, and that is obviously the Children, Young Persons and Their Families Act. Now, we heard time and time again in this House and also in Select Committee that what this bill would do is fundamentally change the core and the principles of that primary legislation. So I think to even claim that we're remaining in the realms of the core values of that legislation is actually quite misleading. So I am proposing that we perhaps change the title of this bill. Perhaps we could change the title to the most fundamental change since the inception of the Children, Young Persons and Their Families Amendment Bill. And just to prove my point, I do want to go back to that core legislation. I do want to go back to those founding principles because I think had we done that in the beginning, that may have better informed the debate. Now, Part 4 of the Children's, Young Persons and Their Families Act 1989 under Clause 208 sets out the principles, the guiding principles for our youth justice system, and I think it's worthwhile going over some of those. And 208A states that the principle that unless the public interest requires otherwise, criminal proceedings should not be instituted against a child or young person if there is an alternative means of dealing with the matter. Now that's an interesting point in there, the fact that it references the public interest requires. Who is the arbiter of whether or not the public interest is being served by having a 12 and 13-year-old moved and dealt with in a youth court? I would offer to the House that we already have enough flexibility within our judicial processes and procedures in our youth justice system for that public test of public interest to be made at that level, and to arbitrarily move 12 and 13-year-olds into the youth court removes that discretion and that public interest test as it sits in the primary legislation. I think C is also worth, again, reflecting on together as we go through the committee's final parts of the committee stages, and again comes to the core issue. And it states, the principle that any measures for dealing with offending by children or young persons should be designed to strengthen the family, whānau, hapu, iwi, and family group of the child or young person concerned, and to foster the ability of families, whānau, hapu, iwi and family groups to develop their own means of dealing with offending by their children and young persons. This Act puts at the core the family. It says that if we're dealing with the children in particular, and they are offending at the level which the Minister claims we're trying to target, there must be care and protection issues in that young child's home. And this Act explicitly states that a core principle is that those family, that whānau, that hapu, that iwi should be a part of dealing with that young person's or child's behaviour. We are removing that through this change because we are taking the family out of the equation. When we move a child or a young person into the youth court, we essentially fly in the face of this principle within the core primary legislation. So I would argue we would be within our rights to look at the title of this Act and say it is misleading, and to say instead that we should pick up on the point made by Judge Andrew Beecroft when he said this is the most fundamental change to this primary Act since its inception. And also at the core of this primary legislation is the idea that essentially our youth justice system, unless the public interest decides otherwise, our youth justice system should be diversionary. That criminal proceedings should, where possible, be limited in their usage for children and young people. Mr Chair. Mr Chair.
Oh, Jacinda Ardern.
Oh, thank you. Thank you, Mr Chair, because I do have some other proposals for other names that we could use for the bill, so I'd like to be able to offer those to the House. So I think that we can see there that this bill does contradict some of those core principles. And perhaps if we go a little further into the core principles, that actually the age becomes an issue as well, because it states under E that the principle that a child or young person's age is a mitigating factor in determining whether or not to impose sanctions in respect of offending by a child or young person and the nature of any such sanctions. Now again, we have a principle here which we are undermining with this legislation. Perhaps then this bill should be renamed the removal of any discretion to test the public interest as set out in the Children's, Young Persons and Their Families Act 1989 Amendment Bill. Not too snappy, I acknowledge, but at least it's a bit clumsy. But I think it points out that we are fundamentally undermining what was groundbreaking legislation at the time that it was introduced. And I do want to go back to that point, because it is internationally recognised that our legislation is unique, and it was well ahead of its time when it was introduced, and still remains at the head of its game. But the changes that we're seeing here today undermine that and contravene our requirements under the United Nations Conventions on the Rights of the Child. So perhaps again, a better title for this bill would be the contradiction of the United Nations Conventions on the Rights of the Child Amendment Bill, because that is at the core of things as well. And I will come back, because I hear members on the other side of the House, who are talking about the victims, and they're actually, they are specifically mentioned as part of the core principles of this Act as well. They are not mutually exclusive, and that is why the public interest test is in there. We do acknowledge that we do have some serious offending amongst our children and our young people, but we could not size that in the Select Committee. We could not size that in the Select Committee, and I will never in this House admit, Ms Gowdy, that you have a point. I'm sorry, I will not admit that in this House ever, because I don't believe that you've taken into account the far-reaching effects of this bill. And again, actually up front, at the very beginning of the core legislation, at the very core beginning of the first schedule, it talks about the fact that this is an act to reform the law relating to children and young persons who are in need of care or protection or offend against the law. It states right up front, at the very beginning of the legislation, the core principles of what the Children, Young Persons and Their Family Act was about, and I do believe that this amendment bill flies in the face of those principles. So why are we doing it? Well, I would contend, and I want to come back to this in my third reading speech because it's perhaps a more appropriate place to discuss that issue there, but I would contend that this is actually about shifting criminal responsibility. It's been tried before in this House and it's failed by other members, not who are now part of the government, a party long past, New Zealand First, have tried to shift criminal responsibility in New Zealand. They were much more overt about it though. And I do believe that although this may not be as overt as that attempt, this is taking us down a similar track. So perhaps then this bill should be retitled the Shift in Criminal Responsibility Act. I thank the members, though, for their contribution to the debate. I do hope that my other colleagues take the opportunity to share their view on what would be a more accurate depiction of what this bill is doing to our youth justice system. Because as I've already stated, as Andrew Beecroft, a much wiser man than much wiser person on the issues of youth justice, have stated, this is a fundamental shift and it cannot and should not happen in this House without a robust debate first.
Mr. Chairman.